We are now ready to have a closer look at the element of agreement as one of the key concepts of contract law. The existence of an agreement is an essential basis and precondition of a contract. We could say that the exceptions are promissory estoppel and quasi-contracts, where there is no agreement, but technically those are not actual contracts. We have already seen that whether there is agreement or not will be determined based on the objective theory of contracts. But what we examine now in more detail are the individual elements of agreement, namely offer and acceptance. There can only be an agreement, and hence a contract, if there has been a valid offer and valid acceptance of the offer. The party making the offer can be referred to as the offeror, while the party that receives the offer and may or may not accept it can be referred to as the offeree. If there is, in fact, an offer by the offeror and an acceptance by the offeree, then we have the meeting of the minds that we already referred to earlier, and which is necessary for the formation of a contract. Remember, however, that whether or not there is a meeting of the minds is determined based on an objective basis. The parties may subjectively not think that there is a meeting of the minds, but from the perspective of a reasonable person or bystander, this is the case. That's the reason why there may be a contract despite one of the parties' unwillingness to enter into an agreement. Every contract begins with an offer. In order to be valid, an offer must contain the following elements: an objective intent to make an offer by the party that is attempting to make the offer. The offer must contain definite material terms that would govern the contract. And the offer and its contents must be communicated to the offeree. Let's look at these elements in turn. Whether there is an objective intent to make an offer is determined by the words and actions of the offeror. There is no objective intent if the offeror uses words that a reasonable person would interpret as an opinion, joke, future plan, a simple suggestion to engage in preliminary negotiations, or an invitation to the other party to make an offer. Let's look at some examples. Let's assume a friend says to you, "I really like your old car and I would like to buy it for $15,000. In reality, your friend hates your car, but is just trying to be polite. Looking at the statement objectively suggests that this would be a valid offer. Subjective intent, or so-called mental reservations that are not shared with the other party, are immaterial. Next, let's assume that your friend says to you she will pay you $1 million if you go to the store and pick up a sandwich and drink for her. Would this be an objective intent to make an offer? Normally not, because unless perhaps your friend is a somewhat reckless billionaire, it's very clearly a joke and not a serious offer that you could accept. There is a famous German case, or perhaps just a hypothetical, that nicely illustrates the concept of an offer under the objective theory. Mr. X, a visitor from out of town, enters the town hall of a small village. He doesn't know that a wine auction is going on. Under the applicable local law, during an auction, the participants can raise their offers by lifting their hand. Mr. X spots an acquaintance who is sitting in the town hall. He raises his hand to greet the acquaintance. Unbeknownst to Mr. X, this means that he is making an offer, and it is interpreted as such by the auctioneer. As a result, Mr. X wins the auction and is obliged to pay for 12 cases of rare wine. In this scenario, would there be a contract under the law? Under the objective theory, the answer is yes, since a reasonable person would interpret his actions at the auction as constituting the making of an offer. The second element is that the offer needs to include definite material terms. This means that the terms of the offer must be sufficiently clear and unambiguous so that the essential terms of the offer can be determined, and if the need for enforcement would arise, that a court would be able to fashion a remedy. For instance, saying to a car dealer, "I would like to purchase this blue Ford Fiesta for $15,000, contains definite material terms. The essential terms are clear, and if necessary, a court would have no problems enforcing this contract or fashioning a suitable remedy. Conversely, mentioning to a car dealer, "I would like to purchase one of your cars for a good price," would not meet that requirement. The third element is that the offer needs to be communicated to the offeree, that is, the person to whom the offer is being extended. An uncommunicated offer is not an offer. Also, the offer must be communicated by the offeror to the offeree in the manner chosen by the offeror. For example, let's say that Joel writes on a piece of paper, "George, I want to buy your car for $15,000. He then puts that paper in his own desk drawer as he is not yet sure whether he's ready to make the offer. 2 days later, George finds the note. Is there an offer? No, there would be no offer in this case. While it was communicated to the offeror, it was not willingly communicated by the offeror, Joel. However, if Joel would have instructed George to go into his study, open his drawer, and read the note, there would have been a valid offer.